And today's presenter is Simon Fodden, and he's a professor at Osgoode Law School and also the publisher of SLOC. And we'd also like to thank our sponsors for today, Center for Innovation Law and Policy, Lawyer Locate, My Support Calculator, Barcode Realty, My Legal Briefcase, and Co-op. So without further ado, Simon.
Well, let's start with a little bit of priming. And to get technology going. Who am I? Well, you've just heard a little bit about who I am. I'm not currently teaching. I retired from teaching about 10 years ago. And about 7 years ago, started SLAW, which is a cooperative legal weblog, and have been publishing that since then, for the last 7 years. So my view is, to some extent, the outsider's view. I haven't practiced, and so those of you who do practice or have practiced, please be kind. What's with the title of the piece? Well, it's taken from, or stolen from, I should say, a book by Philip K. Dick, Do Androids Dream of Electric Sheep? Philip Dick, if you don't know, is a really interesting writer. His books are worth reading. They're quite dark, if that's your thing. Now, I'm not the only one who's stolen from Mr. Dick. The movie Blade Runner was, in effect, based on the book. And it presents a pretty dark dystopia sometime in the near future. And I don't think that, a dystopia in which, I should say, the issue of who is human and who is not, who is mechanical, is difficult and is struggled with. And so to some extent, it bears on what I'm about to talk about, the boundaries between human and technology. Now, I don't have any trouble distinguishing between lawyers and robots yet. And I don't imagine that that's going to be a dire situation in the near future. But it is the case, it seems to me, that the legal profession has some difficulties caused by and with technology. And these are not the only difficulties the legal profession is facing at the moment. And in fact, looked at a certain way, you could believe that it's pretty much of a perfect storm for the legal profession as a variety of influences converge and begin to really destabilize the profession as we've understood it. I'm not going to deal with any of the economic issues, which I know are probably dearest to the hearts of many. I'm not competent to deal with those. I'm slightly more competent to talk about the technology issues, and that's what I would like to do today. I need your help. This is my first law camp session, but my background in teaching leads me to expect that there will be discussion. And I've been known to use silence quite brutally. You're lucky I can't call on names. Well, I can in some cases, but won't. So please feel free to interject, to make comments, to ask questions, to praise, to poo-poo, to do whatever it is you feel like doing during this session. And I will do my best to invite participation where I think it would be helpful, and to leave time throughout the presentation. I should tell you that I'm working on a Windows machine and prepared this on my Apple machine, and so now I'm unable to see my presenter notes. So I will fumfer from time to time and may suddenly wind up talking about property law, which is what I used to teach. So I'm going to break this session into 4 parts, if time permits. I've got various bailout options along the way. And if we finish early, well, we'll go to lunch, you know? So that's the good part. because I'm an academic, the broader questions to some extent interest me more. And I want to talk a little bit about why there's this problem, as I see it, between the legal profession and technology. And when I speak of technology, I'm really talking about information technology and to a large extent social media, but not exclusively that. And then I want to turn to online dispute resolution, something I'm learning about and have a little to share with you so that we can learn together. Then, if time permits, I want to talk about making things smarter for lawyers and for others, and that involves smart data or smart machines. And then finally, I want to touch on the profession's response to all of this, to the problems of technology. So, why is there a problem with technology? Well, as I've said, I'm an academic by training, and my professional deformation puts me in the bleachers rather than in the dugout. That's the last sports metaphor you'll hear from me. And so I like to think a little bit about it, the structural questions, the abstract, if you like. And that's what I want to put on the table, because I see, to some extent, law and IT in structural conflict. Now, I'm exaggerating, or at least dealing with, to some extent, stereotypical aspects of each of these social phenomena. I'm quite happy to admit that. But I think it's to some extent helpful if we do that and see what happens. The first thing that strikes me is that social media is all about sharing, and lawyers are all about confidentiality. And there's a potential conflict. You can never go wrong, it seems to me, overestimating the public's desire to communicate. I couldn't believe Facebook when it just took off in effect like a rocket. I couldn't believe that people were prepared to talk to each other, virtual strangers, about all the things they were prepared to talk about and still are. And it continues to astonish me. Twitter I don't use Facebook so much. And it astonishes me less because it came a little later, and so on and so forth. And so I've realized that there is just no end to people's desire to expose themselves. They are willing to expose themselves to practically anybody at the drop of, a drop of a mouse or something. Lawyers, on the other hand, really have to be concerned about holding information close and tight. And that's something that the panel in the next room discussed this morning, the ethical obligation to do that. And so it's been a problem for lawyers confronting social media. How do I talk, how do I share without sharing things I shouldn't be sharing? Now, I mean, no one's suggesting that you say, hey, I got this hot client today, and man, are they in trouble. Let me tell you about it. That's not the sort of thing. Lawyers are quite gun-shy, it seems to me, and I know this because I run a blog that's cooperative and has a large number of contributors, and it's quite regular that I will ask somebody to become a member of SLAW, and they'll say, I don't know, got to ask the firm, got to think about it. No, I think I won't. It's just too risky, too scary. Now, again, in the panel next door this morning, we heard how lawyers are embracing social media like never before, and there's a veritable explosion. I think there's enough lawyers so that both of those things are true, but I'm interested in currently the potential conflict between open and closed here. And the internet generally likes free and open. By free, I mean free as in beer, and free as in speech. You give things away on the internet. People have called it a gift economy, and I think there's a lot of truth in that. We give everything away on SLAW. All right, we don't charge for it. There's tons of good stuff there. slaw.ca, see you there. But that's, for me, that's nothing special. I come from a university environment where we give stuff away all the time. Students think that they're our customers, but that's not so. Lawyers have specialized knowledge, develop specialized knowledge, hold it close, and sell it. The applications of it. I mean, I'm not meaning to oversimplify what it is that lawyers do. And that, too, creates some difficulties. I haven't had to work with lawyers on this score, but I'm sure people who do explain to them that it really would be very helpful if they gave stuff away. They should give, not advice, I almost said it, but information that's useful. The group that I've tended to work with to some extent is legal publishers, and it's extremely difficult to persuade many of them to give stuff away, because that's how you attract people on the internet, and that's what people expect. And it's not just something you can do a return on investment. I mean, they say, well, what's the ROI? And I say you can't draw that line so directly as you might if you were investing in buildings or land or some other thing. It's a little bit like the casting of your bread upon the waters and hoping it comes back to you. As I say, lawyers, on the other hand, tend to keep and titrate out their knowledge in return for money. It's how they make their living. The internet likes simple and accessible, and law gets ever more complex. Once, many years ago, somebody did a study and counted up the number of laws that there were. I mean, I can't even remember how they did that, but there was just a staggering number of laws, and of course they've continued to grow in number in this jurisdiction alone and become ever more abstruse, certainly to people who are not experts. The internet really does prefer things to be simpler than law does. We often have to explain to people that writing for the internet is not like writing for print. People have continuous partial attention, like some of you now. You're tweeting or doing whatever you're doing. That's cool. I mean, I do that too, right? It's almost impossible not to pull out my thing during the talk and just check my email. And it needs to be accessible because it's global and it sweeps in an unknown number of people of unknown capabilities. And so you never quite know your audience. And I think that there is some structural conflict. This is a little bit more. I'm more uncertain about this. The internet favors graphics, and law is wordy, wordy, wordy. The second thing I have no trouble with. Law is very, very wordy. This is a little McLuhan-esque, perhaps. I mean, there was a time, it seems to me, when the web first came into existence, that everybody was sure that things were all going to turn into icons. And then that thought, the notion that might be the new medium, disappeared, or at least is subdued. But I think it's still there in some measure, and perhaps it can be seen as an extension of simplification in some respects. I mean, we've gone from blog post to Twitter, 140 characters, SMS, uses sleet or some version of it to make it even tighter. 2, Pinterest. Do you know about Pinterest? Yeah? You haven't looked at Pinterest? Okay. We don't have a web connection here, and I should have photographed it. Pinterest.com, is an extremely popular site. It's the new social medium on the block, and it too is gaining untold millions of followers. And the idea there is that you take graphics from wherever you can find them and pin them to your board or whatever it is you do, so that people can look at your collation, your collection of graphics. It's very, very interesting. It actually has appealed tremendously to women, I understand. The largest, by far, number of users are women. And it does appear to be dedicated to consumerism and the delights of the object. But it's extremely popular. And it, in idle moments, I think to myself, what could I do with law on Pinterest? And the answer is not much. When people think of law and images, they think of gavels, which are American. And I spend half my life going around to people saying, please take the gavel off your site. Canadian judges have never used gavels. English judges have never used gavels. Yes?
2 comments since you asked for.
Yeah, please.
First, I'm both a common lawyer and a civil lawyer.
Mm-hmm.
It's a shame that 130 years after we became a country, after 1867, how many of us are bilingual and bijural? The conclusions you're drawing are good for common law. They're not good for other legal systems necessarily. Are law schools training us to be open? No. What are the basic foundations of law? Language and people. Are we trained in law school to understand language? No. Are we trained in law school to understand people? No. What you're saying here is, I think, excellent, right on point. Because it shows to us that law is living in an ivory tower. Law, and we know it from our own perspectives every single day. We have clients who come to see us. How many of us have not realized that the first thing a client wants is to be heard? The client is not coming for a problem. The client comes to be listened to. Are we trained to listen to our clients? No. We're trained to look at clients as a piece of paper. I'm sorry, my client is not a piece of paper. He or she is a human being first. Are we trained to deal with those issues as lawyers? No. We're trained to push them aside and ignore them systematically. There's a crisis, yes, because law is still living in the 12th century.
Yeah, I understand what you're saying, and believe me, I've had some concerns along those lines myself. I'm not sure quite how they mesh with technology right now, but I agree with you. I spent 30 years in law school worrying about that sort of thing. So, yes.
An interesting thing with Pinterest and the legal system is to actually, I think the most interesting thing with that at this point is to look at their terms of use.
To look at
their terms of use.
Terms of use.
Because Pinterest is the latest example of how the internet just tramples over all kinds of copyright. And the way that they've gone around that is, in my close to non-understanding of it, but I've been told that it is actually quite brilliant.
Yeah, I confess I haven't looked at those terms of use, and I have to tell you too that when you actually look at those long, wordy terms of use, you tend to fall asleep along about paragraph 3. They are difficult to read. And that's a lovely illustration, it seems to me, of the potential conflict between law and technology, insofar as the people who use these sites pay absolutely no attention to the terms of use.
And when that user pins somebody else's content and a copy is made on a Pinterest board, who owns that copy?
Okay. So, Sorry.
I think your terms of interest example raises a really good point, though, that while law is wordy, words aren't necessarily a bad thing on the internet. It's how they're presented. And you'll see that long-form journalism and other types of internet publications write very differently in terms of word choice, layout, presentation style than the law is generated. We're still writing legal documents in a fashion that is not readable online.
I agree.
Yeah. And so instead, we're holding ourselves by paper standards.
Yeah, absolutely. That's the sort of thing I was talking about. Law gets more complex as opposed to simple. Yeah.
It's kind of worse than that because we're always constrained by paper, but now we're always just shoving in as many clauses, just in case clauses, because they're all constrained by paper. It's all electronic, so it's like in my hospital room.
I don't know if you can hear, but the comment is we're not constrained by paper anymore, so we're just shoving in as much.
There's some development going on. I think people are becoming a lot more visual. Like I notice it in some of the workshops that I run at law firms, that people they have a problem just listening. It's the articulation, I suppose, of listening. Some of us grew up listening to the radio, but now we're all watching TV and YouTube, so we want visuals to explain things, and our clients need that too. They can't be sitting through reading piles and piles of paper. It's like, make it relevant to me, make it 3 bullet points, make it tweet if possible, or draw a diagram. So I think there's some real. I think lawyers have a real opportunity to take their verboseness and turn it into and simplify it for the client. And I think that takes real skill. And I think that's the next step.
Yep, I agree with you entirely. And it is a real challenge. I don't know if just to interject this while I think of it, and then I know see there are more comments. Have any of you seen? Let me start. Judges don't put pictures in their judgments, except Judge Posner does in the United States. Have you seen any of his judgments? He's taken to putting pictures in, some of them quite unflattering actually to the lawyers involved, and I would have said defamatory, but that's another thing. Sorry, at the back there was a question.
Oh, I was just sparked it. Do you remember when digital visuals first came into the news, 15, 20 years ago maybe it was, and intercutting of techniques in just doing a television program were introduced, and it was sort of jolts per minute. They used a book came out saying people need jolts per minute because they cannot sit through reading. Try reading Winnie the Pooh now, and you'll go berserk by the end of the first page because the pacing is so gentle, and we can't take it anymore. And I suppose that, and another thing, the late Steve Jobs just pointed out that he always changed up in his presentations. 10 minutes, somebody ran on stage with an interruption. Something had to interrupt because you can't. Basically, both of those, Steve Jobs in his presentations and advertising and jolts per minute, they're recognizing the human attention span, back to cognition, the gentleman in the corner. So maybe lawyers ought to take the same recognition of the human animal and our attention span as television producers and first-class presenters. Just a thought.
No, indeed, and I mean that's certainly one proposed solution. The conflict, though, surely comes with the depth and complexity of the material, and lawyers' propensity, correctly perhaps, for complexifying situations. I mean, that's one of the things you want to do to understand it. Your client comes in, you start extracting facts from the client. Facts that the client never even thought were relevant until you've got this giant mound of facts. And it's hard to put that in an infographic, but that's the expectation, perhaps. John, and then over here. Yeah.
It seems to me the internet favors graphics. You can see by the number of things that are now explained by videos. I mean, and the Martindale Hubble, certificate of your status that you can stick on your wall, and they sell certificates. They sell the judges' certificates. They're now selling a video you can buy, put on your website, presumably, to have someone say, yes, and John Gregory is rated such and such. Why someone would watch it. I find, though, this is, my attention span isn't long enough for a video. My attention span says, why would I watch this for 3 minutes when I can read 10 pages in 10 minutes and know a hell of a lot more and think about it critically, because I can go back and say, wait a minute, doesn't that contradict without rewinding and going through again? I mean, spare me the bloody videos. But the number of otherwise respectable and otherwise information-containing sources that go to video. So I think that's your internet favors graphics. It's a bit shorter attention spans, except if I've got 3 minutes, give me content. Don't give me a bloody video.
I'm not favoring any of these
No,
sides.
exactly. No, I'm saying as an observation,
no, I agree.
the push to graphics is pushing to video, which reduces content because you can get a lot more in the same amount of time. If I've got 3 minute attention span, fine, but I can use that more usefully than video in almost every case. If you're showing me a stitch, fine, or how to do a drill press, fine. The law, fine.
Issues on regarding simplifications. I've certainly seen a couple of attempts online of companies to simplify their terms of service, and they'll have the complex version, and on the right they'll have a simplified version in language that is people are comfortable with. Is that dangerous though? Because it's not saying the same thing, and is it maybe burying some important things by omitting them?
Well, you're asking practice questions, and I mean, for me, I think the challenge is to be able to draft simply, and I think you can improve a great deal on a lot of the stuff that passes as terms of service drafted by, unhappy lawyers, I guess. So I think it is not only safe, it's desirable. I think you should do it, and at some point you just have to take the risk. I'm minded, though, the double entry thing. I'm minded of. I said I wouldn't talk about property. Well, I said I would. Short Forms of Leases Act and Short Forms of Mortgages Act. I don't know if you've ever bothered looking at those things. Don't necessarily, but if you do, what you'll see is ancient wordage made identical to modern, or more modern, I shouldn't say modern, more modern wordage in parallel columns. And that was a device that was used by the legislature to take concepts that on which law had been based and carry them carefully without dropping anything and put them down so that new language could import them. And it's very similar to that sort of thing. So there is a simplification process that's been going on, thank goodness, generally. Yeah.
Simplification of drafts can be a breach of professional responsibility for the simple reason that there is a legal rule called contra-drafting, which means that any ambiguity is interpreted against the drafter. And the lawyers know that rule and try to avoid ambiguity for that reason, and that causes the complexity. Of course, I'm not arguing that complexity is unavoidable because of that rule. We can be better, we can do better, we can still shield the client from that rule, but still draft better. And I agree that our law schools don't really teach drafting very well. But there is that rule, and there is the legal context. Lawyers have to think about these rules. It's not just lawyers, it's the legal context.
They do indeed have to think about the rules like the contra proferentum rule. And presumably there's a sweet spot somewhere between, hyper complexity and hypersimplicity, where you've managed to squeeze out just enough ambiguity from the document, but and I know that you can never squeeze all ambiguity out of the document. If you could, it wouldn't be done in words, and the document would be so long that no one could ever read it, that sort of thing. So you have to find the sweet spot. I agree. Yes?
What of the use of the internet, not so much as delivering a message as much as providing the vast number of clients or potential clients that are out there with a much more easy way of cutting into what is seemingly, from a client's perspective, usually a very complex law society. I mean, generally, you've got potential clients that are out there that really see the whole legal genre as being a very complex difficult to understand environment. And the internet really provides a capability of communicating from a legal aspect some of the ideas that are out there and making it a little less scary.
Absolutely. I don't think, I'm not, I think that's a good point, and I'm not intending here to give advice or even to deal with individual practitioners. I think every individual firms and practitioners can resolve these conflicts one way or another, or in a variety of ways. I'm trying to take the broad approach which says, looked at somewhat as the shaggy whole, the legal profession or law, and they have the potential for these conflicts. You wouldn't find them together at a party. Well, you might actually, but that's yeah. Oh, was there a question down here? Sorry.
You had put your hand up for a second.
Please.
Just to take it even broader, this is sort of like, this reminds me of Mark's last old distinction between East Coast code law and West Coast code technology, right? The idea being that it's not just that they're sort of having trouble interacting with each other, one is almost displacing the other. In the sense that law was how we used to structure relationships and had a democratic process to create them. I mean, it's a flawed process at the moment, but there is some kind of input into it. Whereas you're dealing with technology, which is, sort of invented by sort of geniuses on the fringe, and it kind of develops and takes over and structures all of our relationships and communication and we interact with each other, and law's just trying to keep up. And in a society which is being increasingly structured by technology in terms of ways that do change cognition, where people prefer simpler information, they prefer different kinds of interactions, it's not just that laws having trouble keeping up, it's that laws having trouble keeping up with their own.
Well, that's actually a really interesting point, and I'm going to point at you in a slide or two, because I think that's something we have to bear in mind. Yep, I'll come back to that.
A little preemptive, I think, especially given the fact that you're on your first effective slide here.
That's okay.
But I see you're highlighting a series, you're juxtaposing a series of things and a series of differences. I'm not sure that I see necessarily why you think there's a conflict necessarily. Just because something, I think we can all agree that, lawyers are unnecessarily verbose, too wordy. But, I mean, you're contrasting that with the internet necessarily. And I'm just like, these are, it's not apples and oranges, it's an apple and a dragon. And
yeah, understood. I suppose only because, well, this is a conference about how apples and dragons get together. That's sort of part of it. And because they've shown curiosity about each other. Or certainly, which way would we go? The dragon's shown some curiosity about the apple. And people have experienced some discomfort. And I think because societally things might be happening on a larger scale that we're not able to quite see. I mean, that's always the case, but we might be able to glimpse some broader things. But basically, I agree with you. And I'm not, I seem like I'm criticizing law because it's an easy target, and I'm on the inside too, the same as you, and we can always, it's okay for us to do that. We easily criticize the internet. But I actually think, I'm explaining to some extent to myself at least why law should be this way. It should be confidential. You should hold the information close to you. You should develop expertise. You should use it appropriately. And you should do it in words. And the words should be wonderful words and very, very carefully constructed. All of that is, in my view, a good. I'm very much old school, a bit like John seems to be when he says, don't show me the video, give me 10 pages. So. No, go. Just, yeah.
What you talked about in terms of describing sort of inherent or apparent conflicts between these various issues with respect to technology and law has also, as a result of everyone's comments, pointed out that number one, that same technology has encouraged cleaner drafting as a result because the inability for people to maintain that kind of focus. And the other aspect of it as well is there are just all these new branches of law that it has created an opportunities for lawyers.
Yep.
Just last week, when one of my kids said to me, this guy practices space law. Who would have even thought that you went to law school and you're going to practice space law? It was unfathomable to him as a younger person that there would even be such thing. So it's the same thing, while we can't anticipate necessarily addressing all the issues that are presented by virtue of the internet, by the same token, there are all these people that are becoming experts in aspects of it, even if the answer ultimately will be it'll have to be a change in the legal structure.
Absolutely. I mean, I've glossed the law as if somehow you could do that. And the profession, you can't talk about the legal profession. It's actually a series of overlapping professions. It's a scattering, perhaps, of. Let me proceed with one last contrast, and that is jurisdiction. The law tends to be hyperlocal. The internet is global. They say that the law has a long arm. Sometimes it doesn't even reach to Mississauga. For the internet, it doesn't matter if it's Mississauga or Manila. You often don't know. I mean, we know this. And I think that the pressure of the internet on the legal system is fairly clear here. So much communication goes on and is relied on the internet in a global way that law must accommodate in some way. And notions of jurisdiction are bound to become victims in one way or another. So let me come to the point that was made here in the front of the room, which is that we have to change our notion of law, at least to some extent, if we're going to meet information technology halfway. If we're looking for an interface or a boundary, we need to see how that's going to happen. And I came across an interesting quotation by a journalist talking about the death of news media, really, at the hands of the internet. And I don't like to put up stuff that you have to read on but I will in this case. He talks about the death by nibbles and the replacement of journalism by other media, by social media. Now, it's in 3 parts. I don't know if can you all see that? Down to the bottom? Yeah? Okay. I'll just read it so that I know that you're at the end of it. We haven't found the right ways to get people to pay for news and media online, but they have. Talking about other media. We are crying, but they are having a party on the other side of the river where they're not really reporting and sort of journalism and maybe media. I will repeat this because it's important. YouTube, he's Belgian, so his English it's a little wonky. YouTube nor Facebook or any of these other companies aims to be an alternative to journalism, and much of what they facilitate or do doesn't look like journalism at all. A good chunk of it contains written or spoken words, but sometimes not even that. It's not journalism. But you'd be naive if you thought their services aren't often consumed instead of news. It's the same kind of functionality in a different package, after all, and that new package happens to be rather attractive a lot of the time. So it's interesting to wonder whether law is going to be not just unbundled within a law firm as you serve clients, but unbundled and transmogrified generally by these kinds of pressures from the internet. Yeah?
I came across this recently in my law practice. It happens to lawyers. People who are neither lawyers nor paralegals now compete with lawyers. They pretend to be interpreters. They cater to specific groups from specific regions of the world, and they take advantage of the rule that parties to proceedings are entitled to interpretation. And they in fact, I could see that they give legal advice, and they are not, like I said, paralegals or lawyers. They're not bound by any of the bar profession's rules.
Absolutely. But I mean even more than that, rather than services we would recognize as clearly legal services being given by people who aren't authorized to do that, or I mean services that, is that legal? Is that a legal service? Really kind of close. What does it do? It helps resolve a dispute, prevent a dispute, cope with disputes. Is that law? I don't know. That sort of thing. Changing what it is that people want, corporations want. Anyway, that's blue sky. So let's talk about a little bit about online dispute resolution for about 5 minutes, about 10 minutes. And I call it a halfway meeting point because I suspect that law has to change. Law is changed when you use online dispute resolution, but not so much that it's unrecognizable. It's just law, but kind of like through a straw. It's like eating a meal through a straw. It's food, but doesn't have quite the pizzazz that full law does, but it's still recognizably law. Sometimes it's called technology-mediated dispute resolution, TMDR, but that sounds like something you'd attach to your brain in a neural lab. So I think ODR is probably used more often. And it involves, quite simply, technology ranging from telephones to computer algorithms and beyond, if there is anything beyond computer algorithms. It's a very broad notion. It embraces a wide variety of things, and much like Monsieur Jourdain speaking prose without knowing it, you probably practice ODR in some respects without knowing it too, if you have a three-way conference call or something like that to resolve issues. You're resolving disputes and you're using technology to do it. This does it more consciously using information technology that perhaps isn't customarily used by courts. The notion, of course, is to cut transaction. Oh, the good old Windows machine doesn't like my Apple. Cuts transaction costs to the disputants. That's the aim, at least. And it does it by being flexible as to time. You can resolve disputes through online dispute resolution for the most part, asynchronously, whenever you feel like it, at night in your pajamas, early in the morning, whenever it suits you. Your location is irrelevant. You could be in Kamloops. I could be in Victoria. We could dispute without having to get in our cars or our trains or planes and drive to a central location. In theory, it should be efficient because it can do away with levels of bureaucracy, and in some cases, it certainly does. It should be fast. The internet or telephones or other things are generally available and available in some sense at the speed of light. And it produces less emotional contact, which some people see as a good sometime. Right? It takes some of the heat out of disputes. Because again, as I say, you're drinking through a straw, taking a meal through a straw. You lose some of the stuff that can engender heat, or in the case of certain kinds of disputes, anxiety or fear on the part of one disputant. These are just some of the goals. It has some disadvantages, and now Windows is going to do the same thing. It favors simple issues. It's typically used to resolve single-issue disputes, although there are systems available that can resolve multiple issue disputes. It reduces intimacy, which is the flip side of taking the emotion out of things. We derive human satisfaction out of being with other human beings, and there's something powerful about human contact and intimacy when we're disputing. It has importance to us sometimes. Yep.
So one thing that I think about with the online dispute resolution is that, so what happens in litigation settings is that you have the trial. And the eve of the trial is where most disputes get resolved. And that's because there's immediacy, like they're going to get in front of a judge, there's going to be like real cost consequences and stuff. So it's interesting because even though we have all these processes in place, mediation, settlement conferences, settlement discussions, it's like most cases don't settle just before the trial. And so one of the things that I think about with the dispute resolution is how do you recreate that immediacy, like that urgency that you've got to resolve this dispute now. And then the second is, how do you give it teeth? Because what happens with the court is you get a judgment, and that judgment is then enforceable in a particular jurisdiction. With online dispute resolution, there is no kind of, that teeth isn't there. So if you have a litigant who's going to, kind of dig in their heels, there's nothing to kind of get them to the table to use this tool.
Those are both really good problems, and I mean, with respect to the second one, essentially it works best within a single jurisdiction, which is why I chose Kamloops and Victoria, and you have the parties in effect sign an arbitration agreement if you don't have legislation backing it up, and so you've got that which is enforceable. Yes, you're bringing it under the purview of arbitration. And depending on the mechanism that's used, and they range tremendously, there are some actually simple mechanical mechanisms that focus the mind in the way that the trial tomorrow will. You put in your values, and the machine kicks back the solution. You press click, bang. And that's the issue. It's resolved. Now, sometimes you have to take 2 or 3 cuts at it before the algorithm says, this is the sweet spot. This is where you agree. Right? We're rewarding you for being generous to start with. I'm leaping ahead, but we have time is out. So there are ways to concentrate the mind by producing pretty effective, clear decisions in some single, simple issues, such as amounts, money amounts, for example.
With that online, and I'm not sure that it's really had a lot of traction online because I don't think people get it.
Yeah, I think that's right. I mean, I've got somewhere here. I'm going to put my slides up. I'm going to wait. Not going to waste them all. I'm going to put them up. I'll put them up. Let's say Fodden.com Law Tech Camp. Just go to Fodden.com Law Tech Camp. You'll find my set of slides. But you're right. ODR hasn't had as much traction as people thought it would. It has had some traction on eBay, PayPal. Yes, it is. But that's all. They're cousins, at least, there. The game changer may be British Columbia and the recent bill in British Columbia, which came in just this week, just in time for my presentation. They have, and it'll be on the slides. They've mandated, they've set up a tribunal to do online dispute resolution for small claims, 25,000 and below, and condominium disputes, most condominium disputes. And what's particularly interesting is they've, in effect, said no lawyers. And that's got the Bar Association out there and the trial lawyers hot under the collar. That and the fact that they didn't consult, the government didn't consult in the way they said they would. It's really been, it's a bit puzzling as to why the government didn't consult, but it seems they didn't. At any rate, bills had first reading. It's worth taking a look at. If you go to SLAW, you'll see an article that I put up earlier in the week on this. You'll find the links there. And that may change things in other provinces as well.
On search online dispute resolution, there's a description of the thing. Next working group is in 2 weeks. Canadian delegation will be happy to know.
Absolutely, absolutely. The United Nations is doing it, and the European Union is doing it because it is a means of resolving disputes across jurisdictions because you're setting up a new system. So that it will come. Now, I'm going to stop in just a moment, but I wanted to make one last statement, which takes me to number 4 on my list, which is this: that one of the things that disturbed me to some extent is the lackluster involvement of the profession as a whole in the development of technology. And what's the proper response? Well, of course, it's for individuals like you to be as creative and inventive as you are, and to invent new ways of providing services to people and and being generally entrepreneurial. That's wonderful. And in fact, it's a lovely system because if you're successful, people will copy you, and that's the market, and it should work fine. However, it strikes me that it's not enough, and that individual efforts, like so many individual efforts in other fields, aren't enough to change things or to moderate or to modify things, and that the profession as a whole has to do something, should do something. It's very difficult for us to become a profession as a whole because, as I've said, we're overlapping different practices. We're often at one end of the scale there's nothing in common with people at the other end of the scale, yet we both say we're lawyers and we practice law. Nevertheless, I think we should make some effort, not just to produce reports and say that's done and dusted, but in fact to develop techniques, to promote techniques, to implement, to test, to come to grips with this. Because if we don't, as a profession, come to grips with law as it's held by computers, law as it's held by technology, other people will do it for us. The publishers certainly are going to do their best. Other businesses will do it for us. And we will find, I think, that suddenly things aren't quite the way we want them to be. And it will be a little bit too late. You'll be able to cope because you're inventive, because you're creative, and you will cope. But that's not quite the same thing as saying, this is very interesting. There are some real opportunities here. Let us together go out, meet the challenge. We can't control technology. Nobody controls anything, but we certainly can't control it. But we can, to some extent, embrace it and moderate its impact and learn to deal with it. And I would love to see the profession take steps like that, but it doesn't seem to me that there are any of the organs, the law societies or the Bar Association, is really fully prepared to do that. Yep.
Last week I was at the conference organized by the Bar of Quebec, Professional Legal Education. It was about the new Quebec Code of Civil Procedure. We were told in no uncertain terms that things are changing. To give you an example, bailiffs in Quebec, according to the draft Quebec Code of Civil Procedure, would receive the monopoly of legal sales. Period. One big chunk of practice for lawyers gone. So we have two choices: to be behind or to lead the way.
That's a good note to end on. So thank you, Simon.